you have a lot of ideas. And with these ideas, you're creating things. But as you're creating these things, do you even know how to protect what you're creating? Do you know how to profit from what you're creating? Do you know how to enforce your rights if it's being infringed upon? These are some things. And so far, I have come in contact with a lot of creatives that create things, maybe like in the music industry, they create a lot of things, and at the end, somebody else is the owner of what you're creating, or you are employed. Okay, so let's say you're in the fashion industry and you're employed for someone, and you signed the contract, and you didn't even go through the contract to know if your madam or your oga said, any style that you create here is my style. Do you understand? So you're a creative person and you're like, oh, madam, I think that I have never seen this thing sewn like this before. This is something new. And you now sew it, and you now think in your mind that you're the owner of that design. When you came in, you signed an agreement saying that anything you create in your boss's space is the owner of your boss. Sorry, is for your boss. It's not your own. So I just want to just lay that foundation and then just glide through it, and at the end we can just have an interactive session and you ask your questions. Intellectual property is a creation of the mind. So when I say creation of the mind, it's something that you create with your mind. So a real property, which is like an estate or like a house like this, is something that is built that you can touch like this. This is a real estate. But an intellectual property is something that you can go to the next slide, please. So it's something that is in your mind. So I will not read all this, but it's something that is in your mind. So if you are a singer and you write songs, it's in your mind. If you're a literary person, you write books, it's in your mind. If you're a fashion person, you have to first think about the style. After thinking about it, then you sew it out. So it's something that is in your mind. Now, after it comes to your mind, what do? You now make it tangible. Please let's go to the next slide. Okay, so the forms of IP. We have patent, trademark, industrial design, copyright, trade secret, etc. A patent is an invention. So you have someone that creates an innovation, something that is new. That can be protected through a patent. A trademark has to do with names, signs, designs. So just for asking, IKPEN supposed to be trademarked. Now the thing is, a lot of people don't do their trademarks. They just leave it. And then maybe after, they now see that there are like 15 IKPENs on Instagram, or in just someone else is doing the IKPEN and they're not the ones. They will now be, I don't know, trying to see that the other person dropped. The person will not drop their name. So when you are using a name, another person is using a name, and you are now telling me to drop my name, why? Do you have it registered? You don't have it registered, so I will continue using my name. So that's the reason why people trademark their thing. So that when you see that someone else is using it, and the person, you now just write a letter and you send to the person that this name has been protected, you are infringing on my right. If the person does not agree, take the person to court, and the person will pay you damages for using it. So that's one of the reasons. Now, a lot of people, not a lot of people, because people are waking up to this, so people actually go ahead to protect their marks. But some people that do not want to do it, I know of a friend that is currently setting up a company that would be a troll company. So what he would do is he would look for big names that have refused to trademark. He would trademark it, and then he would write to you to stop using his name. And at that point, you would pay him for it. So that's another business. And then we have industrial design. Industrial design is what's applicable to everyone here. And so I'll keep it and then explain it later. Copyright too can be used by fashion entrepreneurs. Geographical indication. So if you have something that is peculiar to a particular region, so let's just say Ijebu Gari now. It's like a name of a place that anybody that produces Gari in that place can call their Gari Ijebu Gari. So it's not the property of anybody, but it's like the name of the place. So they use that name to qualify the quality of the particular product. So that's a geographical indication and all that. Then trade secret is for, let's say she has an institute now. The people that she's bringing in, she has things that has made her to be who she is now. Imagine if somebody that is trying to understand what she's doing now calls her most trusted staff and is like, I will give you this if you can tell me what she's doing. Now, if she did not give her staff any contract to say, all my contact list, all my styles and my procedures and everything are for me, you're not supposed to teach it, and even if you leave for the next 3 years, you're not supposed to start the same business, or if you're starting it, you're not supposed to start it within 100 or these centimeters or whatever around my... She did not put it. She just brought everybody in. Now, somebody would just look at her, oh, she has done so well for herself, get somebody, okay, I'll pay you twice of what she's paying, and that's it. So that trade secret is not protected. For your trade secret to be protected, for you to go to court and say that this person infringed on my trade secret, you have to prove to the court that you took extra measure to protect that trade secret, meaning that you told your staff not to share your client list, not to do this, not to do that, and after that, you actually signed it, and it was in a secret, in a closed place. So, for example, Coca-Cola. How many of us know the recipe here? We don't know it. It's only those people that have signed it. There are even some people that are so, I don't know, that they will even tell you that when you live here, you cannot work for any company that is similar to what I'm doing. That's how they protect their trade secret. And some people even kill for it, because that thing that they've kept for generations cannot just go like that. Thank you. So let's go to the next slide. So what I did here was to pick out the things that are most relevant to people in the fashion industry. So an industrial design right, according to Wikipedia, it's a right that protects the visual design of objects that are not purely utilitarian. So what this means is that, for example, if you have a car now, the tires of the car have a function, the steering has a function, everything that is there has a function, and so it might go under patent, but the way they designed it, let's say like this phone now, that is square and a circle, doesn't really have something that is making the phone work. It's just a design. So how do I put it? For this camera now, this unique design that it has, it's not as if it cannot just be a circular design, but they did this design to ensure that they do this industrial design right for it. So nobody can then create something else that is not canon and make it exactly this design, because they protected this particular design. This Coke bottle now, this Sprite, look at it. It's like this, and it has holes, and that company cannot just come and now create, because they've already protected the industrial design of that. So they are into two. There is the one for textile and non-textile. So for people who are doing things like this, they can do it under the non-textile. Now for we in the fashion industry, for you in the fashion industry, the clothes that you are doing is now what can fall under the textile stuff. So somebody sent me something for her to protect, and she's going to send her samples for me today. Okay, let me not say what she's protecting, since everybody here is a fashion person. But the thing is, if there is a design that you're doing, or you are creating a material that maybe has a peculiar kind of lacing or something, or a particular style that has not been invented, or that is new, that you know that this one is something that I'm doing that is new. Like, I'm not too good in fashion, but there is this shoes that people wear that down of it has a red sole. That one has been protected under this. So peculiar things that make your own fashion stand out, that you don't want another person to do, how you protect it is that you use this industrial design rights. So if you are working for somebody and they have already given you a contract saying that whatever you produce here, the IP of whatever you produce belongs to me, You cannot then do something and now be running to go and protect it, because it's not your own, it's for your employer, because you signed that everything there belongs to your employer. But if you're the one that is creating it and it's in your own time and you do it, then you can protect it under here. So it's for 5 years, 5 years, 5 years. So it's for like a total of 15 years, but you renew it 5 years. But what people do is that instead of having that, so if somebody wants to use that style, that is your style, what they would do will now be to collect a license from you to be able to do that particular style that is your style. So it's very simple to understand. And if they do that style without getting your permission, what have they done? They've infringed on your rights. Then, since this is limited to 15 years, let us come to copyright. Copyright is the protection of creative works, literary works, musical works, and artistic works and all that. So if you can draw the design, you can draw it and then do it under copyright. The reason why people do both, if it's allowed in your country, is that design rights ends after 15 years, but the duration of copyright is for your lifetime and for 70 years after. Yeah. So that's why people do both. Now the thing is, copyright is automatic. Once you've done your work and it's fixed, once you've written your song, written your book, done everything, it's already yours. But now the thing is, if you have that right till 70 years after, God forbid if someone should infringe, or not even God forbid, because some people, they even want people to infringe on their work. So just imagine if you have something and Samsung or Apple infringe on your work. Have you not hit jackpot? So for some people, they even like infringement, not for people that cannot pay, people that can pay. So imagine if your work is infringed upon, and now that it's infringed upon, you want to prove that you're the one that first did it. How will you prove it? That means you start saying, oh, I cannot find that book where I wrote it, that book where I drew it, and all that. But if you've already gone to do the official registration with the government, that means they have the picture of what you did, even if it was 17, 30 years ago. If someone infringes on it, you can always go and pick that drawing, or you already have the number and everything, so you can use it in court. And then finally, we have trademark. So that's what I already spoke about. Your name, your logo, everything about your name, logo. If you have slogans also, you can also protect your slogans. So the duration of this is as long as you want to do it, but you have to renew it every 7 years. Please, can we go to the next slide? Okay, so this is the last slide. Fashion infringement. First of all, you have to note that you are the first police of your work. So that you protect your work doesn't mean that the government will now be looking at, oh, who infringed on Juliana's work? No. You are the one that maybe, okay, let me just give an example. So I used to do jazz before, I told you, jazz music. So, so then I wanted to do something like a jazz hangout and all that. So I did a trademark, Jazz for Peace. And that trademark, then I wanted to do it, so I just did it, and I just kept back. But the people I wanted to do it with were not so serious, so I just dropped it. Last year, my husband was driving somewhere, and he saw a flyer, and it was come for a concert, Jazz for Peace. He just snapped it and sent it to me. I said, wow. I just carried carried everything, sent it to my friend to help me do the litigation part of it. He wrote to them. As I am talking to you now, they are even saying that we are not in the country. We are not even in the country, that they've relocated to Ghana. He said, don't worry. He now served them through newspaper publication. So that's how it is. And why do I have the mouth? Because I've trademarked it. So that's it. So you are the first police of your work. It should be registered. Now there are some people that they don't register their work. It's an unregistered mark. But the thing is that that mark is so known. It's a known mark. For example, Coca-Cola. Even if they come to this country and they say they don't want to trademark, even if you now say you want to do Coke fashion wear or something, Trademark office will not trademark it for you because everybody knows Coke. They already have a standard goodwill with them. So you, now that you are starting, you're not saying no, that you don't want to trademark your work. Somebody can easily infringe on it. So it should be registered. Then you can get a lawyer. You can, so if you should get a lawyer and someone is already infringing on, what the lawyer would do is that they would first send them a cease and desist letter, meaning, please, this particular work is the work of my client, don't use this work again. That one is being a nice guy, being a gentleman. And then after that, we are advised as lawyers to try alternative dispute resolution, meaning mediation, conciliation, arbitration, and all that. Meaning that you sit down by a table, they sit down there, and you're like, why are you using my work? Don't use my work, this one, that one. And then finally, you can then move to litigation. So that's the basic thing about it. Let me see the next listing. Is there anything? Thank you very much.